It was February the 27th of this year when Lieutenant Marjorie Mason's body was found behind a vacant home in an isolated section of Scott. She had been shot and raped. The Air Force nurse was allegedly abducted the day before as she went shopping for furniture in North Little Rock.
That night, the highway patrol chased her car. Two men got out, ran opposite directions, found out, the car was registered to her, went to her apartment, found that she was missing. And I don't know if it was the next morning or a couple of days later, but a farmer found her passport and some other papers of hers in one of his fields.
One of my friends in the office called up and told me that what had happened. Bright sunny day, no cares in the world except for having fun. And then tragedy hits.
I opened the door and there were 3 Air Force representatives standing there. And I knew at the time that something had happened, but I envisioned a car accident or something like that.
The phone rang and my wife's cousin started crying. He started crying. He gave the phone to me, and it was my dad. And he had told me that Greta had been killed. That she had been kidnapped.
Now Barry Lee Fairchild is facing capital murder charges in Lonoke County in connection with the crime.
Fairchild, who was one of our 2 prime suspects since Sunday, was spotted at a house near Arkansas Tech. The Russellville Police Department surrounded the house when Officer Chamberlain, one of our K-9 units, arrived with Jubilee. The man was coming out the door struggling with the officer. He told the dog to attack. The man received numerous lacerations to the head.
What emotions were you going through at the time?
It's just hard to believe. Anger, ready to take on the world, start World War III. And when it first happened, because it's senseless. 2 guys got in her car and kidnapped for what? She didn't even have time to enjoy, the life. Because once she got into Little Rock, within 2 weeks, she was kidnapped and killed.
Greta's funeral was with full military honors because she was killed while in uniform. Church doors opened to go outside. Her nursing staff were in uniform and they came to attention and saluted her.
If you'd gone to her funeral, you would have thought a damn president had died, because everybody was there. And she was loved by everybody. I don't know one person that did not respect that girl because of who she was.
I reconnected with her boyfriend, Cade, who had bought tickets to fly to Little Rock, Arkansas the week she was killed to propose to her. But he, of course, didn't get to go.
Okay, and that is your signature here? Yes, sir. Okay. The rights form is witnessed by myself, Lieutenant Wagner, Wayne Chaney, North Little Rock, and Swift of Lonoke County Sheriff's Department. Now, Barry, can you tell me where you were at on about the 26th of February?
26th of February. Was
yes.
It on the Saturday? Was that on the Saturday?
Yes, sir, it was.
Yes, sir. We picked this woman up.
Who's we?
Me and Harold.
Harold who?
Harold Green.
Where'd you pick this woman up at?
Up there by that furniture store.
Little Rock, North Little Rock?
North Little Rock. North Little Rock furniture store.
What street is that on?
Washington Avenue.
What happened after y'all got in the car?
We drove down the Scotts and went back off in the field, went across a cattle guard, through an opening, and pulled up there in front of the old house. And then after we pulled up there, he got out the car with the woman.
Who's he?
Harold Green.
Harold Green?
He got out the car with the woman and went in the house.
Did he have the gun on him?
Yes, sir.
What did you do?
I just got in the car.
What was you doing?
I was just going through papers.
What papers?
And a pocketbook.
Did you hear any sounds from that house?
Yeah.
What kind of sounds did you hear?
A gunshot. 2 times.
And after that ordeal of terror, despite the desperate pleas from Marjorie Mason for her life, they took a gun and they placed it against the back of her head. And they fired a bullet into her brain.
Did you see Green with a pistol?
Uh-huh.
Okay. And he still had it in his hand?
Uh-huh.
Okay. And did he say anything after he shot her? Did you ask him anything?
No, I didn't ask him nothing, but he just said, forget it. And I said, you didn't have to. He said, that's all right. That's just that. Now, forget it.
In his confession, Fairchild said Harold Green was with him the day of the attack. Later, the judge read a joint defense-prosecution statement that Green was in Colorado at the time of the murder.
After y'all left, where'd y'all go back to?
We come down New York Garden up this big old hill. That's when the police got him behind him.
Okay, you remember what police agency it was?
It was a state trooper.
State trooper, okay.
Yeah. And then when he got him behind him, we just speeded up.
Okay, y'all driving her car.
Uh-huh. Right. And after we got a big old hill, we just pulled off in a field and just jumped out the car and took off to run.
The jury watched a videotaped confession Fairchild gave at the Pulaski County Sheriff's Office at 3 a.m. after he was arrested in Russellville. The prosecutor called the sheriff to deny a defense allegation that Fairchild was exhausted and confused at the time of the taping.
In fact, we were, in my opinion, very nice to him. In fact, I was very concerned about the wound that he had received in Russellville, and I think we got him a couple of aspirins, and he was not coerced or threatened or intimidated in any way.
Well, I went to these folks' house, and I told them when they make a phone call, is there any way I could get a taxi? So they was making a phone call. So about that time, the police come up there, come in the house and get them.
Okay, just try to get away.
No.
Okay. Now, you've got a bandage on your head. What happened to you there?
After they brought him out the house and had me stand inside the car, I had the dog jump on.
Did you also take him back to where the nurse was killed?
Right.
Okay, you showed him where that was?
Mm-hmm.
All right. And did you also take the officers to locate some of the victim's property?
Yeah, right.
Okay,
right.
what property was that?
A watch.
The most emotional moment of the day came when Marjorie Mason's father took the stand. The psychiatrist from Florida came here to identify a watch he had given his daughter as a birthday present. A watch Fairchild took and allegedly sold to his sister for only $20. Mason's mother's hands shook as she talked about the last time she saw her daughter wearing that watch.
She said, I needed a little more professional watch. She said, all I had was my Snoopy watch.
And is there anything else you want to say?
No, sir.
Okay. Ending this deposition, time is now 7 a.m.
Major Dill testified, as did the sheriff last week, that the confession was given under no pressure.
Specifically, did you ever see Tommy Robinson hit him with any type of gun or do anything like that?
Absolutely not, no, sir.
I was kept up to speed by my dad some because he went to the trial. My mother kept me, who lived in Dallas, kept me apprised of what the prosecutor, Chris Rath, was telling her.
She fled for her life. The only thing she had left, he'd taken everything else she had from her. She just wanted her life. And ladies and gentlemen, he took that too.
The capital murder conviction came after 2 hours and 45 minutes of deliberation. The jury of 6 men and 6 women was then carefully instructed on assessing a penalty, either life in prison without parole or death.
We, the jury, after careful deliberation, have determined that Brandy Fairchild should be sentenced to death.
The victim's mother, Sandra Brecker, had been in the courtroom for much of the trial. Today, she feels justice was served by a brave jury.
I'm just thankful to the Lord for the verdict and the justice. I'm thankful to the prosecuting attorney and the deputy attorney and the jurors for seeing that justice is done.
And now, what do you do?
Go back to Fort Worth and go back to work and continue my life.
Fairchild was placed in the custody of the Lonoke County Sheriff's Department for transferal to the Department of Correction. His execution date has been set for November 10th of this year.
The trial went as expected. He was found guilty. A lot of times, the victim knew the suspect in some way, form, or fashion. But the situation with Greta is complete strangers that she had no dealings with, only been in Little Rock for 2 weeks. It's not something that happens very frequently.
And then the amount of BS that you have to go through to the trial, anything they can believe, they'll put up anything to make he's the victim. And then it's just a disgusting thing to go through.
And then follow this string of appeals based on whether or not he was that was a fair trial. And Judge Isley, who I respected a lot, comes in, and of course Fairchild complicated the situation by saying, I don't want to fight if I'm just going to be sentenced to life without. And then more and more and more. It's just a song of technicalities after that.
A subdued Barry Lee Fairchild was brought to the federal courthouse in Little Rock this afternoon. What was to be decided today, whether Fairchild could voluntarily end all of his appeals and be executed. Just this past August, Fairchild said he'd had enough. No more appeals of his conviction. He wanted to die. Today he was found competent to make that decision, but he didn't.
As long as you're alive, you have a chance to, to do things, and Mr. Fairchild has finally begun to recognize the fact that he does have a chance of overturning his conviction.
Now Fairchild wants to be retried, his conviction set aside. That's because his attorney feels he was possibly arrested without probable cause. His new court-appointed attorney says that has given his client a lot more hope.
I think he doesn't feel the situation is as futile as he did before.
Prosecuting attorney Chris Raff says he's not surprised by Fairchild's decision, but he is disappointed. Fairchild would have been the first execution since 1964.
And the more we wait, I think the more people lose faith in the criminal justice system, and I really don't blame them when they see this happen.
Barry Lee Fairchild will not die on March 8th. Federal Judge G. Thomas Isley issued the stay, expressing concern about the outcome of a new IQ test performed on the inmate yesterday. Evidence submitted by a clinical psychiatrist shows Fairchild has an IQ of 56 to 64, putting him in the mentally retarded classification. The question is whether Fairchild understood his Miranda rights.
Some people just don't understand what all those things mean, that what you say can be used against you in court. That is, it's going to hurt you, it'll probably convict you, it'll probably put you in prison.
Ruth Luckeson, a mental retardation expert, told Judge G. Thomas Isley, Fairchild suffers from mild mental retardation and probably had this defect before he was 18. Fairchild was convicted when he was 29.
Some people are just agreeable individuals who tend to go along with what other people are saying or doing. Generally, people who are intellectually disabled have a life in which they have been used to being dependent on other people. They're used to other people making decisions for them. They're often more likely to be trusting of other individuals. They're more likely to be deferent to authority figures. They were often taught, for example, that police officers need to be respected. You need to do what they say, regardless of what they're telling you to do. If they tell you to sign something, you sign it. Does it matter if you know what it means? Well, no, the police officer told me to sign it, so you sign it. If they tell you to say something, you say it. If they tell you to answer something, you do it. And so you'll often see compensation in the form of acquiescence.
Also testifying today were 3 death row inmates, including Fairchild himself. Fairchild told Isley this morning that although he understands his rights now, he didn't at the time of his arrest. Parker, another death row inmate who legally advises other inmates, said Fairchild may, quote, understand the rights but not the consequences. What it boiled down to was the cop told him to confess. I don't think he knows or ever knew.
But if you're only asking, do you know what this means? They will tell you yes to everything. And if you never followed up, it actually sounds like they're pretty knowledgeable. They sound pretty capable. You can replace that with Miranda rights. Do you understand that you have the right to remain silent? Yes. Do you and so you can kind of go through this and they will say, I understand. Yes, right, sure, of course, yes, yes. Sign here. They sign there. And so a lot of individuals, especially lay people, are going to look at that and they'll say, I heard him say he understood it. Of course he understood it. But that is not the same thing as understanding anything. It's just agreeing. And so that we're seeing is acquiescence, which may also be understanding. Sure, certainly they could actually understand it, but that's not enough to actually go on.
New test results indicate Fairchild understood his Miranda rights and the consequences of waiving them. The psychologist whose March 3rd report to Judge G. Thomas Isley resulted in a 4th stay of execution told the court today, although mild mental retardation exists, Fairchild could understand his rights. This is only one of several tests performed on Fairchild over the past several years. A Florida psychologist told Isley in a telephone interview that other tests finding Fairchild competent were completely inadequate. He said Fairchild's past record indicates he's been mentally retarded or suffered from brain damage for more than 23 years.
I don't have a time machine. Nobody can say that. We don't have a time machine you can crawl into and go back and see. Who knows?
Dr. Johnson previously found Fairchild's IQ to be in the mentally retarded range. However, after performing and reviewing other tests and information and examining Fairchild's behavior, she now says Fairchild is not mentally retarded and currently understands what Miranda rights mean.
The two that were given that obtained IQ scores in the 60s were the Stanford-Binet and a Wechsler intelligence test. And the interesting thing is those are the two probably the best supported. When people talk about the gold standard of IQ testing, they're usually talking about one of those two tests. But the value of those two tests is that they are what we call comprehensive measures of intelligence, and they produce what we call full-scale IQ. A full-scale IQ means that this is an intelligence measurement that's looking at a broad range of different aspects of intelligence. The issue then is there are other tests, for example, the beta test, the revised beta, which was the one that was, I think, a 78 or somewhere in the high 70s. That is not a comprehensive intelligence test, and it does not give a full-scale IQ measure. According to the records, this is an individual who was primarily illiterate, couldn't really read, couldn't really write.
Time is 2:31 a.m., so you have 11th grade education. Can read and write, is that correct? Right.
There's a lot of records that note that he had difficulty with verbal comprehension and communication. So there are some difficulties with speech. So the interesting thing is that the beta test does not have tests of verbal intelligence.
Well, I went to these folks' house and I told them when they make a phone call, is there any way I could get a taxi? So they was making a phone call. So about that time, the police come up there, come in the house and get them.
If a person does differently on these two tests, one argument someone might make is, well, the higher test scores, the more accurate, because that shows they put forth the most effort. If you think about running a race, if you run it a mile in 7 minutes and then you run it in 10 minutes, well, how fast can you run? It's the faster speed because you did better. So some people will apply that same concept to intelligence testing, and it often makes sense if it was the same test, for example, or if we were measuring it in the same way. In this particular case, though, we're looking at very different tests. Another issue, which was not addressed in the records that I looked at, but the beta test is often given in a group format, particularly in correctional settings, and this was given at a federal prison. I've worked at a federal prison myself. I have actually proctored these group assessment. We did not do it for intelligence testing, but we do it for personality assessment or other things where it's just like a questionnaire. So if there is a reason for why they're doing poorly or well, you may miss it. But when we're doing intelligence testing for a comprehensive measure, it's one-on-one, no one else is in the room. And so you often will pick up a lot of behavioral cues as to why they're doing poorly. You know, are they just messing around? Are they just like looking around? You know, or if they're doing very well, are they very focused? Do they seem anxious? Are their hands shaking? There's a lot of things you can pick up that are very useful. In a group format, you're going to miss most of it. And it's not clear whether it was done in an individual or group format.
The closest evidence relating to Fairchild's 83 mental capacity is an 83 review by the Arkansas State Hospital. Tests were performed then to determine Fairchild's competency to stand trial. Dr. Albert Rosendale, the psychologist who performed those tests, says Fairchild was uncooperative at the time. When Fairchild was asked to recite these rights, he rapidly goes through the 4 steps. Fairchild is then quoted as saying, quote, "I didn't did it. My lawyer told me not to talk about it." Rosendale says in light of that statement, Fairchild understood his rights. The credibility of the report has been questioned, however, due to discrepancies in Fairchild's education record. In a lengthy opinion, Isley said, "In sum, Mr. Fairchild is a sane adult who understands the difference between right and wrong and has the capacity to conform his conduct to what is right."
I think what Judge Isley gave us in this opinion is a real bright line that says you can't just parade into the courtroom an IQ test and say this person's low, subnormal, or retarded and then absolve them for their responsibility for their criminal act.
In Isley's opinion, he mentioned something about the fact that ultimately adaptive functioning is more important than IQ test scores. So regardless of which score is accurate, really adaptive functioning is what matters. It's more important. And it's interesting he says that because that's actually a pretty good point. A lot of psychologists and a lot of researchers would agree with that. We do tend to rely more on the adaptive functioning. The funny thing is, at least in the records I reviewed, nobody did an assessment of adaptive functioning. So sure, it's more important, but who did it? Did he have impairments in adaptive function? We know certainly his academic achievement was quite poor. He didn't have much of a work history, but there's a lot of potential explanations for that. But someone had to have done the work to know that, and it didn't look like anyone ever did. Arkansas State Hospital also had something where they mentioned that he refused to complete an IQ test that they tried to give. That doesn't mean malingering, but it does mean uncooperative. It means this person is not, really participating. So does that make it a challenge to assess this person? Yes, it does. It doesn't mean he's not genuinely impaired, but he's making it harder for them to support that.
Late this afternoon, Hall filed appropriate paperwork to appeal the decision.
I have no surprise at all because I could tell by the way the hearing was going that we were ultimately going to lose.
Clark says Hall's actions in appealing the decision is but one more step in what has been a long battle, and believes court review could keep Barry Lee Fairchild alive for at least 2 to 4 more years.
The excerpts that are included in the court records don't include a lot of things, though, that today would have been standard. But today we have actual tests that you give the person. We have structured interviews. We have all these different tools that we'll use. And so it may just be that I'm missing the part where they really did do all those things. I also happen to know that all the tests we use today were not in existence at that time, and it's possible they really didn't. So I can't say it wasn't done here. I know it was frequently not done at that time, and it was not mentioned in the report, which does raise some interesting questions there.
Barry Lee Fairchild comes into federal court with the executioner's clock ticking. He'll die in 1 week unless a stay is granted. He has confessed to killing a nurse, but now claims that admission was beaten out of him back when Tommy Robinson was sheriff in 1983.
That is not true. It
So-
sounds good, it looks good in print, but it's not true.
Fairchild was bandaged in his videotaped statement, but Robinson says the wound was from a tracking dog, not from police brutality, denying allegations that the suspect and his brother were hit with a phone book to make them talk.
I mean, you're not going to hurt anybody with a telephone book. I mean, you're going to use Jacksonville or Searcy or Little Rock or whatever. I mean, what would a telephone book do? You're going to beat me with a telephone book every day, and you're not going to hurt me. You still think?
Oh, phone books work. Yellow Pages especially. Little Rock, yeah, because they don't leave bruises. You can smack somebody right square on top of the head with them, and they'll do anything you want them to. Of course, I never did that.
How often do you think that would be used?
Well, let's put it this way. There were some people there at the sheriff's department that went through a lot of phone books.
The most shocking thing was to hear a police reporter talk to me about a practice of hitting suspects on the head, cushioned by with a baton or some object, cushioned by a telephone book. The telephone book was such a distinct recurring image, and I'd never thought of the physics of it. Would that really block a bruise?
What was reportedly happening is you would put a phone book on the head of a suspect, and then what you would do is you would pound that phone book with the baton. And what it did is it would scramble the brains, and it would show no bruises and no evidence of abuse whatsoever, but it would be extremely painful.
The judge decided even if the admission was forced, it wouldn't change Fairchild's guilt.
If the most guilty person is beaten and forced to confess, the Constitution says that conviction based on that confession cannot stand. But what else is important is that what Barry Fairchild said in that confession may well not be true.
You're accusing an inmate of being a liar, but all you have to convict them is a confession. So inherently, you have contradictions that were never reconciled. And it would seem at the end of the day that the mother of the victim was punished the most. This was not comforting from a law enforcement investigation standpoint at all.
But now Fairchild only has a few ways to stop next week's walk to the death chamber. His lawyers are making final court appeals and asking the governor to grant a stay.
Now has got to be the time for people to take a stand and to urge the governor to become the protector of the rights of poor, indigent people in a way that the federal court in this state has refused to do.
Judge Isley was such a respected judge. And the takeaway from his decisions, I think, is that by this point in the appeals process, it was a dead end. So based on what he was capable of doing as judge, he was making his rulings at this point in time. Might things have been different? Possibly, if they'd been raised sooner.
This case presented some very difficult issues, but the proof that the petitioner put forward was never terribly strong.
This morning, the Capitol Rotunda was a sounding board, its marble walls used to echo the protest of several civil rights groups out to stop Barry Lee Fairchild's execution.
People came in from all different parts of the United States to protest this case, which I think in some ways was irritating to Native Arkansans.
They took petitions to the governor's office, the names of 1,000 voters, their first step into pressuring Clinton into granting a stay, something the courts have refused to do. But Clinton was outside, planting a tree, that ceremony briefly interrupted by the ACLU.
Killing another one bring those back to life.
Well, that's
quite apart from the fact whether he did it or not, which is a separate legal question.
That's maybe your opinion, but that's not the law in Arkansas.
The governor told reporters he'll study the case before deciding, and his answer will be based on facts, not politics.
They are people whose position has not prevailed in court. So not in courts, not in the legislature, not anywhere else. And so now they're trying to politicize it. I'm going to do my best to keep politics out of it.
What was so striking to me with Governor Clinton at the time, he had protests at the governor's mansion. He had the national press coming in. In fact, when he ran for president, this issue came up because at that point, he was the only one who could do anything. Bill Clinton was the only one who could do anything.
Clinton hasn't made up his mind, but says that right now he sees no reason to keep Fairchild out of the death chamber.
Well, it's obvious the governor hasn't read the pleadings and doesn't really care. He's just going to sit on his bottom and let Barry go to his death, but we're not going to roll over and play dead.
His attorneys want another hearing in Little Rock's federal court, again based on claims his murder confession was forced, but with new evidence. Now others are saying that deputies tried to beat them into admitting to the same crime. The case is also at the 8th Circuit in St. Louis. Hall wants all 9 members, not just a panel, to rule on whether the brutality claims merit a stay.
There were at least 6 real suspects in this case, real defined by the sheriff's department. The way they define real is by arresting you, bringing you in, and trying to beat a confession out of you. That's what this sheriff's department did in this case.
Fairchild's lawyers say he broke under the pressure and made up his involvement just to stop the abuse. But he reportedly wasn't the first to talk. Randy Mitchell also confessed, but that statement was discounted by a lack of detail.
It's not a question of who could provide better details from within themselves. It was a question of who accepted the suggestions by the police officers. And Barry Fairchild is a very compliant person once he is broken.
The allegations have been made before. They've been denied by the law enforcement officials. It's just a matter of them coming forward with new evidence that I'm certain that the law enforcement officials will deny again. At this point, I don't really see that it changes anything.
But Judge Arnold and the appellate panel didn't agree. The stay was granted, and now District Court will hold another hearing on whether Fairchild deserves to die. Barry Lee Fairchild has been the abuse route before. This is the second time his lawyers have claimed a forced confession, that he admitted to killing an Air Force nurse to stop the beatings. But this hearing promises new evidence.
A bunch of direct evidence that the jury never heard, both that Mr. Fairchild's confession was coerced, that there was a pattern and practice of coercion by at least a dozen young black suspects in this same investigation.
3 of the former suspects were shuttled in from prison. All swear they were beaten before Fairchild, but didn't confess. A former deputy took the stand ahead of them, saying he heard Fairchild getting cursed and slapped, testimony the Assistant Attorney General didn't believe. Gillian has a flock of lawmen ready to deny the abuse charges, including Larry Dill, the deputy accused of swinging the punches. The judge has told Fairchild's lawyers they must prove that he did, and that the confession was a lie.
Judge Isley clearly seems to have that in his mind, that not only would he have to be convinced that it was coerced, that it was also untruthful.
Would you say that it was kind of a regular routine to kind of rough up people?
Of course. Don't ask me where they came up with 13 suspects. Have no idea. You have to have enough cognizance to pick out the bad ones from the good ones. Dill didn't have that. He was, oh, this is what I think, and this is the way it's going to be. When all the circumstantial evidence came together, there wasn't anything to connect it to anything else. That's all it was circumstantial evidence. Like 13 people? No. I wouldn't even want to attempt to connect all of them to one incident.
Both parties had predicted that this case would last 3 days. There's no doubt in my mind that it will go through Friday sometime and maybe beyond that.
The day's most controversial statements came from Fairchild's former defense attorney, who said the coercion claim dates back to 1983, shortly after Fairchild made his videotaped confession.
And then argued at the, during the jury trial that the confession was coerced and was unreliable.
O'Brien said he defended Fairchild minus important information. The prosecution never told him that other suspects had been questioned about the murder, including Fairchild's brother, who reportedly failed a polygraph test.
We might have investigated him further than we did. As I testified, I interviewed Robert Fairchild, but that was to get information about his brother.
The inclusion of another person or the inability to exclude another person from a crime would, at the very least, stop an execution. But it doesn't happen that way. Once someone has been convicted of a crime, it's very difficult to go back and exonerate them for a number of reasons. One of the reasons is that, any evidence that you want to use should have been presented in that original crime, in that original case. And if it's not presented in that original case, you can't use it on appeal. There are some post-conviction reliefs that are available, but they are rarely successful. And so you really have one crack at it. If you don't have all the evidence at the time, if you don't have the DNA at that time, if maybe your case came at a time where DNA was not as common as it is now, then you are out of luck many times.
There was something I saw in the records where allegedly, 2 other inmates say that the brother had told them that he had done it. So if that's true, maybe he was trying to protect his brother. That might have been more important to him than other things, especially if he didn't think that talking about his brother was going to help him out of his own case. Sort of what's the benefit to both of us going down?
If there was a case against his sibling, they would have convicted the sibling. I mean, that's what just doesn't actually make sense. Why wouldn't you convict that person? No case has been proven against Robert Fairchild. However, I would argue you have many families where one child does bad things and they have many siblings. So are you as a sibling expected by law enforcement to turn in a family member? Is that a standard? Or is it up to law enforcement to prove cases? I mean, if you're a sibling and you aren't involved and you don't know about it, that could be terrifying to family members.
Randy Mitchell is the hearing's star witness. His tale of abuse almost mirrors Barry Lee Fairchild's. Both claim forced confessions to the same murder, with Mitchell saying his beating started at home. But his ex-wife later told the court she didn't see or hear the scuffle.
She remembers them coming in and being rough with him and taking him out. Now, whether she remembered a knee here, an ankle here, a fist there, that doesn't neglect the story.
Mitchell also says he was taken to the Little Rock Police Department, his face still bloody and swollen, and that he reported the brutality to Sonny Simpson, who was chief at the time.
I met Randy Mitchell here in the hallway about 2 hours ago, to my recollection, the first time I ever saw him in my life.
The lawyers who put Mitchell on the stand also learned that Simpson doesn't have a record of Mitchell's injuries, when department policy dictates that he would.
The state has prosecutors. The state has the crime lab. The state has the police. And a lot of police from several jurisdictions were brought in on this. Then usually you get a court-appointed attorney who might be working out of an office about the size of this one and is supposed to defend the guy.
There's a tremendous amount of pressure for them to get someone. And there's a lot of pressure on the prosecutor to get that conviction. They're not thoughtfully thinking, I don't care who I get, I'm gonna get somebody, it doesn't matter if it's the right person. But sometimes the pressures that are placed on them will drive them to start engaging behaviors that end up being in that same fashion. For the Reid technique as an example, police officers are taught these certain techniques that will tell them if a person is lying. Research has shown that they are very ineffective. They're not accurate. And actually research shows that judges, psychologists, psychiatrists, police officers either do no better than at chance at determining if a person's telling the truth or not, or only slightly better than chance. You have all this information that's gathered, it's put on the prosecutor's plate. Their job is to get convictions. And yes, they're also supposed to pursue justice and truth. Often their political career is measured in convictions. And if everyone's telling them that this person did it and there's no other suspects, the family wants to see justice. The community wants to see justice. And so if you have some doubts yourself, you might push them away a little bit.
Well, I'm gonna stand up for my sister's death. The dad can't speak. my sister was such a good girl, or, she would probably forgive the guy because she was so religious. I can't do that.
Mason arrived from Florida in time to hear Willie Washington say that he and another suspect were abused before Fairchild was arrested. Testimony intended to establish a pattern of brutality by sheriff's investigators and to cast doubt over Fairchild's conviction.
I think he's guilty. There's no doubt in my mind that he's guilty. And I can live with that too. Whether or not how he, got the confession and all that, I think it's just something a bunch of people just made up. They have 8 years to make up a story.
I can't forgive the man for what he did. I can try to understand what created that man to prevent somebody from becoming that man, but that's all we can do from where we're at today. I believe that if somebody would have maybe gave Barry Lee Fairchild a chance his first couple of times when he got into trouble, maybe they would have prevented this.
John Walker took the stand this morning. He lived in the victim's apartment complex and was questioned at the sheriff's office after her murder.
And when they got me to the sheriff's department, they put a book on top of my head, and then they hit me in the top of the head with a blackjack repeatedly.
During Walker's testimony, these deputies were brought in, then lined up in the courtroom. He quickly tagged 3 as his abusers, but one of the deputies Walker named didn't work for the department back then, and another was on a narcotics raid. Tommy Robinson wasn't thrilled about being called to the stand. The former sheriff thinks Barry Lee Fairchild's request for a new trial is a waste of taxpayer money.
If I had a just cause to sue someone in federal court, if I got a half a day, I would be lucky. And here this guy's got weeks and weeks of testimony tying up the federal court.
In reality, to put on a death qualified jury, to have a capital case to go on for maybe weeks, to expend all of those resources, and then the appeals that come afterwards. And then a lot of these folks are indigent. And so the state pays for 2 attorneys for them because they're entitled to what's called super due process. It actually costs more money to attempt to give someone the death penalty rather than to sentence them to life without parole.
Randy Mitchell says the former sheriff helped rough him up, and Willie Washington claims Robinson held a gun to his head.
Now, these are all thugs and ex-convicts and people serving time in prison, and I don't think the judge is going to believe anything they say.
Robinson thinks everything the former suspects have said in court is the product of coaching, and the assistant attorney general says it might be.
So much of their testimony fits together very neatly, and in some cases it doesn't, but in many cases it does. And to me, it suggests that it has been programmed some way or another.
Anytime that 13 men come forward with the same story about being beat and almost forced to confess to a crime and probably not believed because they are Black men, that's a huge problem with our criminal justice system. That's a huge problem with our court systems that would disregard all of those statements from 13 individuals about how they had been treated and how they had, the police tried to force them through abuse into confessing to a crime. That goes to a larger issue about how disparate the treatment is for African Americans in our criminal legal system.
Barry Lee Fairchild's attorneys are armed with boxes of old documents and a battery of new stories about brutality at the sheriff's department. One of those tales of abuse was footnoted by Worthy Springer, the doctor who treated Michael Johnson just hours after Johnson was questioned by deputies.
It is acknowledged from the deputies who testified that they had a scuffle with Mr. Johnson. There's no dispute about that. They admitted that sort of thing. Their version of the scuffle that they had with him is at odds with his.
Gillian's job is to stifle the shouts of abuse, charges brought to a federal judge by Fairchild. They're intended to bolster his claim of a forced confession and to prove he didn't kill Greta Mason.
In many cases, we brought out real serious problems with the testimony, and certainly in many cases problems with the credibility of the witnesses. So at this point, I feel like we've done all we could do.
Federal Judge G. Thomas Isley traded his robes for an overcoat, then walked outside. The lawyers were already standing on the sidewalk, and Barry Lee Fairchild had been tucked securely into a marshal's car. This afternoon, the traditional courtroom setting was out. The fact-finding needed a field trip. The tour took Fairchild back to the Pulaski County Sheriff's Department, where he claims investigators forced him to confess to killing Greta Mason, the charge strong enough for the judge to want to see the building building. But the department has been remodeled since Fairchild was questioned. It doesn't look the same as it did in '83. The sightseeing tour did uncover a lot of changes, but none more unsettling than those found at the murder scene. The farmhouse has gone from run down to rickety and ominous, an eyesore made uglier by a fallen tree. Fairchild saw the house and walked the grounds, but never said a word.
What was projected to last 3 days turned into 17 as attorneys wrapped up closing arguments. Attorneys for Barry Lee Fairchild tried to raise a considerable cloud of reasonable doubt as they attempted to poke holes in the state's case. Their main points, they argue, is that Fairchild was coerced by deputies to confess to raping and killing Marjorie Greta Mason in 1983. They say the confession contradicts hard evidence, and that there is a doubt about a watch linking Fairchild to the killing.
The key piece of evidence is a watch that sheriff's deputies found with Fairchild's sister. In his confession, he says he took it from Mason's body and sold it to the sister.
Did y'all take any money from the lady?
Yeah, about $70.
Okay, how many jewelry?
Watch.
Who got the watch? Well, did you take the watch off, or did
he took it off?
What did he do with it?
Get it to me.
One of the most outrageous parts of it, years later, after the conviction, on appeal, one of the appeals, defense found a reference to the watch that Marjorie Mason was wearing, linked him to the crime in what may have been the most persuasive piece of evidence for the jury. It turned out that there was a note in a police file that there was a difference between the watch that Fairchild's sister had and the watch Mason wore. And that was in the police file and not turned over to the defense. That should have been the end of the story. The minute that was discovered, that should have been the end of the story, and heads should have rolled. The fundamental rule is the state has got to turn over what it has found about the case to the attorneys. They had an obligation to turn it over, to make sure it was known, to call up the prosecutor, hey, you're making this point, but we know this.
Every piece of the state's case that they had nailed down very tightly for many years, and that Judge Isley thought had been nailed down, are now loose. They're loose because the truth is bubbling up.
Assistant Attorney General Jack Gillian has a different view of Burr's performance today.
I think he has to do more than create a reasonable doubt. This isn't a jury hearing this case now. This is a judge who's reviewing it on collateral attack. And to me, he has to do more than create a reasonable doubt.
To add to the complexity of the case, Fairchild now says he would accept a life sentence as an alternative to death. But his attorneys say that's not an admission of guilt.
He understands that the courts tend to see doubt about guilt as a reason not to have somebody sentenced to death. All he's saying is that he's willing to let the courts consider that.
More information was coming out and it still wasn't moving the dial. Everything remained at a standstill. If you say that Barry Lee Fairchild did this crime, yet there's no physical evidence to tie him, and if you say somebody else did the crime that someone knows about, there has to be some evidence gathered somewhere. I mean, there has to be something. You could say perhaps it doesn't match this defendant, but what was so puzzling to me is there was never any discussion about evidence, like hard evidence for a rape and a murder. You often have body fluids. You often have very basic measures that tie defendants to crimes. And that was really not discussed in this case. And you say somebody confessed, that should be good enough. But if you look at every component of the confession, none of it adds up. So even if you say, you've told me you've committed the crime, but everything you're telling me is inconsistent with the facts. I mean, even if we have no physical evidence, we're just going on your word. But at what point do we accept your word if your words don't match up? The words simply didn't match up again and again.
Greta Mason's family came to Little Rock from different parts of the country, 5 people with one purpose, to make sure Barry Lee Fairchild keeps an appointment with the executioner.
The only thing I can call justice is a life for a life, not life in prison.
The only thing is justice is a life for a life.
That dramatic plea was aimed at the parole board, which will make a recommendation on whether Fairchild deserves the governor's mercy. Mason's family doesn't think so and has sent a letter to the Capitol explaining why.
While we do not thirst for vengeance, we hope for an end to our pain. We cannot resolve our grief while this process continues. Please bring it to an end.
This case has been looked at for over 10 years by every court in the United States, from the Arkansas Supreme Court, from the Lonoke County Circuit Court, to a federal district judge, over and over.
Fairchild's case hasn't left the courts. A decade of appeals has kept him on the docket and out of the death chamber. And now the victim's family is saying enough is enough.
When you can take somebody that admits to a murder and take 10 years to execute them, you're not being tough on the crime. That's a joke.
The convicted killer's family walked in first, followed closely by the victim's relatives, all headed for a Supreme Court hearing to determine whether Barry Lee Fairchild dies for the crime or lives because of a low IQ.
He has tested very low on the most comprehensive IQ tests there are, so it is fresh ground and requiring a stay of execution.
But Fairchild's mental capabilities have already been the subject of a federal hearing, and after 4 days of testimony back in 1989, the judge decided that Fairchild is not retarded. But Fairchild's attorneys have a completely different view because they're looking at a new state law.
It's clear that people with mental retardation should not be executed in this state, and that is a constitutional ban that applies to everyone.
That law, passed just this year by the legislature, also says mental retardation must be determined by a jury, not a judge. So Fairchild's attorneys think he deserves a new trial.
Jury must look at this. Judge Isley cannot be the last word, and Act 420 says that he cannot be the last word.
Now the Supreme Court must decide who's right. That ruling will probably come Monday, just 2 days before Fairchild is supposed to face the executioner.
What if a jury rehearing this case says, okay, he's guilty of kidnapping, he's guilty of rape, but he's not guilty of murder, and sentences him to a term of years? He'd be parolable, not subject to the death penalty at all.
Late today, and just before the filing deadline, Fairchild's attorneys filed a motion to stay the execution. It claims Barry Lee was not the triggerman in the murder of Greta Mason.
One unfortunate thing that I could admit is it appears that there were 2 people involved in the commission of the offense, and the state has never been able to develop evidence as to exactly who the other person was.
Felony murder in Arkansas is a system by which if you are in the commission of a felony, any murder, anyone that's killed in the commission of that felony, you're responsible for that. Even if you didn't pull the trigger, even if you were not the person that committed the murder, even if it wasn't a murder, if the person just died and you were committing a felony, then you can be charged with murder. Once you get the death train going, it's so hard to stop it. In the Liddell Lee case, he was executed without the state ever testing the DNA in question. And the DNA was tested after Liddell, many years after Liddell Lee was executed. And the DNA found that there was an additional male's DNA on the murder weapon. And so that additional person has not been located or found. But these are things that should be determined before someone is executed. There should not be credible claims of innocence that are not fully explored before someone is executed, especially if it's as simple as taking DNA to a lab and testing it. There should be no reason why we would execute someone versus testing the DNA.
Law enforcement involved in this said at the time, we don't know, and it's not likely that Barry Fairchild is responsible for this, but he probably knows who did it, and therefore we don't have a problem with his being punished. That's not really how the judicial system works. And again, if you have a family member who's murdered, I would think you would want the murderer punished, not someone who probably knows the murderer. And that also spoke to me in terms of quality of police work. The idea that you would say, he probably knows, but you're the one doing the investigation. And that would be good for you to get to the bottom of.
Some people have said that your other son might have been the one who did it. And today, Barry Lee's attorneys filed an appeal saying he was not the trigger man, he didn't do it, and so he shouldn't be executed. How do you feel about that theory?
That he didn't do it? He didn't do it.
How do you feel about the theory that your other son is the one who
He didn't
did
do it neither. They can't put that one dropping on another one. That's what it look like they're doing.
Jack Gillian spent the morning waiting to hear from the judge for a teleconference call that also included Fairchild's attorneys and their latest push for a stay of execution.
They're arguing that Mr. Fairchild's conduct at the time of the crime, his participation in the crime, was not of such a significant nature that he is eligible to receive the death penalty.
The call came at 12:30 and ended an hour later with a court order. Fairchild will be brought to Little Rock tomorrow morning for an emergency hearing.
This argument obviously has piqued Judge Isley's interest, and he seems very concerned about the issue that they've raised.
So the hearing will focus on whether Fairchild deserves the death penalty, since it was never proved that he fired the shots that killed Greta Mason. The judge also wants to know if Fairchild has dropped his longtime position of go free or die.
He apparently is now willing to let his attorneys make arguments that could result in a reduction of the sentence.
And if his sentence is reduced to life without parole, the state will immediately appeal. So whether Fairchild lives or dies might not be decided until the final hour. Barry Lee Fairchild was in and out of the federal courthouse within minutes. That's all the time he needed to say he's dropped his old position of freedom or death and would take life without parole.
I guess he just wanted to make sure that Barry knew he was giving up his opportunity to die.
Fairchild's last-minute change of heart led to this emergency teleconference between the lawyers and the judge. The call for a ruling on defense claims that Fairchild doesn't deserve the death penalty.
There was really no evidence outside of the trial record, which said that he was sitting in the car when the shot was fired and didn't plan the murder.
An hour into the call and just 7 hours before the scheduled execution, Fairchild's death sentence was gone, replaced with life without parole, because the judge feels he wasn't the trigger man and didn't intend for Greta Mason to die.
Mr. Fairchild could not have been sentenced to death in the first place, therefore he is, quote, actually innocent, unquote, of the death penalty. Not innocent of the crime, but innocent of the penalty.
Proving a case beyond a reasonable doubt is a fundamental tenet of justice in this country. And when that does not happen, when that's not the standard that, or the proof that is presented beyond a reasonable doubt, then we all suffer. It erodes the rights of all citizens when we're not using that standard, or prosecutors are not presenting enough evidence and juries are accepting iotas of evidence and speculation and circumstantial evidence in order to secure a conviction.
In Isley's opinion, that Barry Lee Fairchild did not have the willful disregard of life, the willingness to kill Marjorie Mason. He didn't have that. And therefore, his death penalty should have been vacated. Who in this whole scenario does have the willful disregard of human life? It's us. It's us who are the ones who are knowingly going in to literally execute someone who can't get away. We are the ones who have all the power, the state of mind to do it, even if we have reason to doubt.
Since Barry Lee Fairchild was arrested 13 years ago, the case has been emotion charged. Accused of the brutal rape and murder of a young Air Force nurse, Fairchild's complete role in the case has never been known.
No promises or threats been made to induce you to make any type of statement? No, sir.
This videotaped confession fueled speculation that Fairchild's confession was physically coerced, but the jury found him deserving of the ultimate penalty.
We, the jury, after careful deliberation, have determined that Barry Lee Fairchild should be sentenced to death.
Protests surfaced as the state was set to execute Fairchild in 1989. Fairchild supporters raised the same issues raised now: the role that Fairchild played in the murder and Fairchild's mental capacity.
Should Mr. Fairchild be executed in any way, it would make persons who had anything to do with the sentencing and execution guilty of murder.
But a federal court ruled Fairchild was mentally competent.
I don't know if Barry Lee did or the person with him. I don't know, but it makes no difference to me. He's guilty of a capital offense and he deserves to die for it.
A lethal injection was administered at 9:01 p.m. and the coroner has pronounced Barry Lee Fairchild dead at 9:11 p.m. this 31st day of August, 1995.
One of the things that's so hard to do in a situation like this is to actually forgive someone for committing such a horrible crime against your flesh and blood.
Probably not a good thing, but I hated people, period. And then I remembered how she was and how she felt about Jesus and the Lord. And I ended up watching The Little Drummer Boy. And at the very end, he talks about Jesus and how he loved people and that all hate is wrong in any form. Kind of like a bell went off and aired, you know, ding. That's when I started healing, but for a long time.
She had so much more to give. She might have saved the world if she could have lived with the heart that she had. Losing her is a sacrifice, but to forget about her and let her die is a much bigger crime than having to put up with the pain of talking about the situation or exposing the true problem. Sure, people care, but to me, it's like prayers. Prayers without actions are only prayers. Saying you care without actions is only American bullshit. I mean, I'd have felt really bad, you know, if they'd have damn killed somebody that didn't truly do it. But I've seen enough evidence in my case to where there's no doubt in my mind. You can't explain how he had her watch if he wasn't there. If he bought it from somebody, who'd you buy it from?
Typically, when a death sentence is vacated, then it's not reimposed. That is an extreme circumstance, and this is an extreme scenario, whereas one court vacated the death sentence and then it was reimposed by a higher court.
I was certain there was not enough evidence in this case to put someone to death. And if there wasn't enough evidence to put someone to death, there probably wasn't enough evidence to hold them in life in prison. But I also felt that so many people were connected to this case that to re-examine the facts would have been embarrassing to too many people.
If we're going to execute somebody, we ought to be absolutely sure. Even then, I don't see the point. If we've got someone who's handcuffed in state custody, they're not running away. What's the point of that level of retribution? They can't harm us. They can't, even if, they did the crime, can't do anything. It's like shooting a chained dog. And most people, I think, would recoil from that.
If this case were happening now, there would be more legal resources involved and people would step up and examine this case. I think we're living in a different time where people don't accept a ruling from years and years ago if new evidence surfaces, that while the court system is limited, you would have an elected official who would step up, that these are different times that the public would reward that. And I think the outcome would be very different.
Closure, some people might find closure in certain things, and it's not a big issue for me. What is done, cannot be undone. It's a lifetime ordeal when something like this happens. People you don't know for no reason snatch somebody away from you. It's not something you get over. You have to live with it, but you have to move forward at the same time. But you never get over it.
In Greta's case, there is no justice. She's dead. The only justice can be is to do something about it in today's world. And to me, that's the only justice we can give her, is don't forget about her and do remember that she did mean something.
Biggest thing is a big loss out of my life. Part of my heart's gone. And that's the biggest thing about it, is the loss. that will never return. And there's a song by Bread that is so true to me. It's called Everything I Own. And it's about loss. I'm willing to give anything to have it back.